Can I just check and make sure that you can hear me? And if you can hear me, I will presume that that everybody is on, can hear me okay.
Yes, you're loud and clear. Thanks.
Terrific. Welcome, everybody, and thank you for attending my session regarding the evolution of the LGPL license. I am going to presume that everybody here has been doing more Zoom conference calls and conferences than they ever thought that they would do in their life over the last several weeks, and I am one of them. I do have to say that it is really odd and bizarre to do a presentation like this, knowing that there could be hundreds of people attending, and I have absolutely no eye contact, no visual feedback from people. It makes the presentation very much odd, I guess is the right way to say it. I know how radio personalities must feel now. One thing that I will do out of an abundance, I guess, of ego, and that is whenever I do tell a joke, I will stop for a minute or so, because I will presume that you will all be laughing so hard that you'll need a minute or so to collect yourself. And then at the end, I'll give it about 5 minutes, so that if you want to give me a standing ovation at that point, I'm very willing to accept that. Again, by way of introduction, my name is Paul Criswell. I am an attorney practicing. I work out of the Boston area, and I am the chief legal counsel in the United States for the Cute Company, and handle a lot of the company's legal affairs here. And the occasion for my talk here is that, beginning with version 5.7 of the of Qt, the 5.7 release, certain modules of the Qt open source software are now being licensed under the general LGPL license version 3. Previously, all of these open source modules were available under LGPL version 2.1. And the version 3 is a significantly different license than version 2.1. And it's an occasion for people to sort of pause and understand what is going on. The LGPL version 3 is a complete rewrite of the LGPL. And let me just read to you from the Copy Left and GNU General Public License Comprehensive Tutorial and Guide. This is something that's put out by the Free Software Foundation. And in their written description of GPL version 3, they say, overall, the changes made in the GPL version 3 admittedly increase the complexity of the license. The Free Software Foundation stated at the start of the GPL version 3 process that they would have liked to oblige those who have asked for a simpler and shorter GPL. Ultimately, the Free Software Foundation gave priority to making GPL version 3 a better copyleft license in the spirit of past GPLs. Obsession for concision should never trump software freedom. So that's the context for what happened with the LGPL. And let me start, maybe, I think it's important to talk a little bit about how we got here and what's going on. I remember back in the 1980s when the free software movement really sort of began. And the idea at that point was that software was something that should be part of the public commons, and that both software as a functional device, if you will, and civilization would be better off if software was dedicated to the public and was part of the things that could be used as part of the public use. And so the idea was that if you create or use free and open source software, you had to offer it up to the world. And other people could use that software, and it was share and share alike with regard to using the source code for the software. But a policy like this is something that's usually created by government, which enacts legislation. And in this case, it was being created by private individuals, private parties. And even though it was intended to be a social movement, there was not governing authority by the people that were doing this. And so this required a new tactic. And what people invented was something called the public license. And the founders of the movement used this non-negotiable license agreement. And think of it as a cross between legislation and a contract, so that that as a result of that, the general public license and the lesser general public license were created. And they were created by people like Richard Stallman and Evan Moglen, who were some of the founders of the Free Software Foundation. And you know, what is it that Gandhi said about this? First they ignore you, then they laugh at you, then they yell at you, and then you win. And I can remember absolutely this progression with regard to free and open source software. Originally, when people started talking about it, people said, "What? That'll never work." Then it became the subject of jokes. Then as we moved through the 90s, people started talking about what a disaster it was, and it was going to destroy your business, your family life, and Western civilization, or all of civilization, if anybody used free and open source software. And then it became ubiquitous. And now it is something that is absolutely a part of all of our everyday lives. But I think the important thing to remember with regard to the licensing is, very much like legislation, it has become a cat and mouse game. So the license agreement and or legislation is enacted, and then people whose activities are controlled by that license or by that legislation figure out ways to get around it. And then the license or the legislation is revised, and it addresses the actions that people have taken. And then they figure out new ways to get around it, and then it's revised again. So proprietary vendors had developed ways to get around the LGPL license or the GPL license, first version 1, then version 2. And the new versions have been reactions to that. So version 3 really can be best understood as something that is intended to stop people from circumventing earlier versions of the open source licenses. So a little bit of background: LGPL version 2.1, which is the previous version, is a standalone license. It is something that stands alongside the GPL version 2.1, but it is a separate license. There's a new structure, new and different structure to version 3, and that is that the basic license agreement is the GPL version 3. And the LGPL is an annex or an amendment to that basic version 3. So anything that is in the GPL license, the version 3 of the GPL license, is applicable to what you can do if your software is licensed under the LGPL version 3, except for those specific amendments, or what it's called existing additional permissions, that are added by the LGPL over and above everything that is provided by the GPL. So as a developer, and I'm presuming that a lot of the people that are attending this session are developers, you have a choice to make. Do you use free and open source software, or do you use proprietary software? And in particular, do you use software, free and open source software that's licensed under the LGPL version 3? And this is particularly relevant in the context of Qt software, because it's a dual licensed software and you have your choice of essentially using the same software either under an open source license, in many cases the LGPL version 3, or under commercial terms. And the only difference is the licensing. And that is what I am here to talk to you about to help guide you through those choices. And I will be the last person to tell you that the choice is the same under all circumstances. It is not. It absolutely is not. And if you are, there are many circumstances where use of free and open source software is completely and absolutely appropriate for a particular development project. And if you're willing to comply with the requirements of the open source license, then if you're willing and able to comply with that, then why not use it? Because the license fee at that point is zero. But it's important to recognize that there is a cost and a burden in complying with those open source licenses. And in some circumstances, those costs and burdens are enough that it makes it easier and cheaper to use commercial software, even though you may have to pay a license fee for it. And of course, I will be honest with you, I am here to talk to you about particularly those circumstances, because that's how the Qt company makes its living with regard to commercial software. So I'm here to talk to you about what are those particular circumstances, what are those particular instances where the cost and burden of compliance might be specifically high, so that it's actually easier and cheaper to use commercial software. So I'm going to run through some of those circumstances, and you as developers, as engineers, as managers, as marketing people, you will have to make the choice. And my hope is that I can guide you. And if some of this particularly rings a bell, that you will be convinced that what you really need to do is to use commercial software. So let me talk first about compliance programs. And in a lot of companies, the company either doesn't have the ability or the willingness or just doesn't want to run an effective compliance program. And so remember that the very first and basic rule of using free and open source software is that you have to provide complete and corresponding source code to your customers for any free and open source software that you include in your product. And in order to do that, you have to have a compliance program, so that if somebody contacts you and asks for that complete and corresponding source code, that you can do that. So let me read to you from, this is a document called the Guide to GPL Compliance, 2nd edition. The author of this is Eben Moglen from the Free Software Foundations, one of the absolute godfathers of the free software movement. And what he writes here is that software governance is a phrase we use to describe the process by which businesses document and control what software they take in, what software they distribute, and what license terms they incur or offer to those inbound and outbound transactions. Good software governance is the key to minimum cost preparation to meet compliance obligations. Let's take a hypothetical manufacturer of consumer electronic devices. The Acme company. The Acme, and he goes on to talk about what open source software Acme embeds in its products. Android operating system, the OS kernel, Linux, some LGPL libraries, BusyBox, GNU utilities, etc. And it says that Acme chooses not to provide CDs or USB memory sticks containing GPL source code along with its product, preferring instead to place a written offer for the relevant source code in product packaging or documentation. So remember, you have to be able to provide the source code to all of your GPL software to any customer that wants it. And one of the ways that you can do that is you can just ship a copy with your product, or you can have a written offer that says, hey, if you want this, let us know and we'll provide it to you. As a result, Acme has obligations to provide complete and corresponding source code for all copylefted programs it produces to any requesting party. In order to meet these obligations, Acme's governance process begins from the bill of materials listing the component parts of the software stack in each product that it makes. License analysis is used to confirm the licenses applicable to all the items on the bill of materials before development begins, and in an iterated process as development continues and the bill of materials is modified. A set of license texts required to be reproduced in product documentation is built from the output of the license analysis step and is included in the product packaging and online documentation. For any copylefted software Acme takes in, whether embedded in hardware components or provided by third-party software suppliers, it automatically requests complete and corresponding source code. By exercising its rights as a user, Acme prepares to meet its own obligations. All source code taken in by Acme under copyleft licenses is carried, modified, or unmodified through the build process. When the product containing the software stack is released, the complete and corresponding source code for all copylefted components is placed on a public-facing website indexed by the product model number and a revision code or an arbitrary hash code specific to the device and software version. This stack mark is also printed in the product documentation and is represented by a QR code on the exterior product packaging. A similar stack mark accompanies firmware upgrades delivered as digital files to sales intermediaries for placement on their own websites. Legal review before a product release verifies that Acme's forbearance obligations are also met. As a result of these steps in its software governance process, Acme is confident that any user of its product who wishes to exercise her or his rights under the GNU family of licenses can request and receive source code instantly, even without opening the box. So maybe all of that sounds familiar to you. I am sure that many of you work with companies that have a very robust compliance program. I am just as sure that many of you work for companies that don't have that type of compliance program. So if that doesn't sound familiar and comforting to you, consider maybe that your company should be very careful about utilizing free and open source software as one of the bases for its product, and that maybe using commercial software is a good insurance policy to make sure that you don't have to worry about those compliance issues. And by the way, this is only for what is clearly free and open software. It is not even talking yet about the viral issues that may be involved. Second part of this is with regard to having expertise and advice regarding compliance. And I am going to confess to you as a lawyer, long time in practice, that a tremendous number of lawyers and a tremendous number of in-house counsel don't have a clue as to how to comply with open source software licenses. So if you want to have some fun, walk over to your in-house counsel's office, knock on the door, walk in and say, hey, I have a really interesting issue with regard to open source software that I really need to get your advice on. And then just take a moment to appreciate the fear that flashes through their eyes under those circumstances. Because free and open source software and the licenses that go with them are not something that we are used to dealing with. First of all, the licenses are written in technical language rather than legal language. And second, there is really very, very little case law that just interprets what is meant by all of the various licenses. And then finally, once we maybe figure some of it out, the licenses change because the next version comes along. So you have to decide as part of your choice here whether you have the resources that are really going to allow you to get good advice and allow you to create that good compliance program. For example, you have license compatibility issues because not all free and open source software licenses can be used with one another. The Apache license and the GPL version 3 license, for example, are incompatible with one another in some aspects. And remember reading somewhere that Apache licenses can be used in GPL version 3 projects, but GPL version 3 can't be used in Apache projects. I could not explain to you what exactly that means, and I'm going to guess that there's a large number of in-house counsel that couldn't do that either. And therefore, you may need to use outside resources in order to get good advice and be able to understand what you need to and what you can do under those circumstances. And then, you know, it's the traditional argument against open source software was that it has this incredible viral effect and it's going to make you release all of your products source code no matter what, and it's going to destroy your business. And clearly that has proven to be a red herring. People have figured out how to use open source software compatibly with commercial software over the years. But a couple of things have happened. Number one, version 3 has changed the structure of that boundary language. In other words, it's changed the structure of what it means to be a program that is infected by the viral aspect of open source software. I will be the last one to tell you to go back to the 1990s arguments about this is going to turn all of your source code into open source software. But there clearly are certain aspects of things that you have to be very, very careful about. And you can see in my slide here some of the language that is used that I just would suggest to you is not necessarily as clear as a bell to give you guidance. And one of the specific goals of the version 3 licenses was to take definitions, particularly definitions of things like derivative works that previously had been defined using reference to US copyright law, and to attempt to make that language and those boundaries compatible with copyright law worldwide. And to do that in a couple of sentences, or at least at most a couple of paragraphs, which I would argue is a Herculean task that may be difficult to achieve. So that's circumstance number one. If you work in a company where you don't believe that you have the resources to run a robust compliance program, you need to think carefully about whether it's worth it to purchase commercial software under those circumstances. Let me turn then to software patents. Because if you work in an industry where patent protection, and especially software patent protection, is common and necessary, either to protect your own product or to protect you against claims from other people, people who may be your competitors, then I would suggest that you need to think twice about using version 3 open source software. Let me go back to this comprehensive tutorial and guide with regard to the GNU license and provide you with what I think is the absolute essential encapsulation of the attitude of the true free software believers with regard to software patents. And section 9.14 of this comprehensive tutorial says, software patenting is a harmful and unjust policy and should be abolished. Recent experience makes this all the more evident. GPL version 3 takes a more comprehensive approach to combating the danger of patents. So understand that version 3, that this version 3 software is actively hostile to patents. I'm not going to comment on the philosophy of that and whether that is correct or not. Obviously, reasonable people could have different opinions about that. But if the value of your product, if the value of your company is dependent in some ways on the portfolio of patents that your company holds, then you need to be very careful. The easy case, as I have listed here, is the situation where you are selling something. It utilizes free and open source software that you have utilized, that you've modified, that you've passed on, and somebody using that open source software that you have modified necessarily infringes your patent. Then you automatically grant them a patent license. You cannot collect a license fee for them using your free and open source software. That people argued that that was implied under the previous versions of the GPL. That has been made explicit in the GPL version 3 and the LGPL version 3. Well, let me go on to some other and perhaps more subtle issues with regard to that. So what happens if you contribute or modify some of the GPL code? You use that in part of your product. Your patent covers something that is done in that GPL program, but nothing having to do with anything that you have modified or that you have contributed to that program. It is expressly the case that that doesn't matter. Anything that is necessarily implicated by what is called a contributor version of the GPL code, you automatically grant the users of that a patent license. So even if that overall program, even if the parts that you have modified have nothing to do with your patent, if the patent covers something that is necessarily implicated by that program, license is automatically granted. And that is true even if your patent is issued later after you have started to distribute your program. Once you have gone this route, there is no turning back under those circumstances. And so that's something that you need to consider, but consider also for a second, as we are working in the technology industry, I think a lot of people have in mind that mergers, acquisitions are something that is very common, something that can significantly contribute to the enterprise value of our companies. And a lot of times, if you have a company with a large and rich patent portfolio, there's a synergistic value that's created if one of those companies with resources acquires a smaller company, because the smaller company may not have had the patent portfolio, or it may not have had the wherewithal to really enforce a patent portfolio, and therefore its patents were not worth as much. But not the case if it gets acquired by a company that has a rich patent portfolio and the ability to enforce it. But if your company is acquired by somebody who has that extensive and valuable patent portfolio, they automatically grant a license to their patent portfolio for the GPL version 3 code that you have distributed. So if there are what are called essential patent claims, meaning claims that are necessarily infringed by what you have done in your GPL version 3 code, then your acquirer automatically grants to those customers a license to use their patents. Then finally, there are issues with what are called discriminatory patent licenses. And these are licenses, you know, I guess I would just refer you to the version 3 license agreement, because ultimately what has happened is that there have been all sorts of different schemes, if you will, whereby people have devised ways to be able to enforce their patents against customers, or I should say receive a license fee from customers because of their patents, getting around the implied patent licenses of the GPL version 2.1. And those have to a large extent been, or to the extent that people could do it, those have been specifically prohibited under the LGPL version 3. Finally, one other item to take note of with regard to, again, to software patents, and that is if you have sub-licensed, if you've taken a license from an independent third party with regard to one of their software licenses, or excuse me, one of their software patents, and you are distributing GPL code that is covered by that patent, but you are supposed to collect and pay a royalty to your licensors with regard to those products, then you have a problem, because the GPL version 3 license agreement, again, automatically grants to your customers a license to that patent that you have sub-licensed. And so that doesn't mean that you know, you're in a you know, in an untenable, or excuse me, a situation that there's no way out of. What it does mean is that you end up paying your licensor a patent fee under those circumstances, and you can't collect it from your customers because of the GPL version 3 license agreement. Let me go back again for 1 second and mention one more issue with regard to acquisitions, and that is that a lot of large, sophisticated companies have done an analysis of various open source licenses, and they have blacklists. Many of you probably work for companies that have blacklists that prohibit you from using software that is licensed under certain open source license terms. The Abfero general public license is one of them that's particularly you know, particularly aggressive with regard to open source, and that's on a lot of people's blacklists. GPL and LGPL version 3 are particularly on people's blacklists. If you have a product and you are being acquired by another company, I have been involved in situations where the acquiring company, as a condition to closing, will require you to rewrite, to redevelop particular products, and to take out of those products software that is licensed under these blacklisted licenses. So I had a particular client that spent about 6 months between signing a letter of intent and closing an acquisition, where and then during that 6 months they spent the entire time rewriting their product to take out various pieces of software that were licensed under blacklisted licenses. Let me talk for a second about something called TiVoization, a great and modern term. So named after TiVo, the DVR manufacturer. And what they did was they, and a lot of other people did this at the same time, they used free and open source software. They made the requisite offers and allowed people to have absolute access to the source code for all of that software. But they included in their product various means that shut the device down if it detected that there had been any modification to the software. So sure, you could get the source code to the TiVo, the software that ran the TiVo device, but there were hardware mechanisms within that device that if you modified that software in any manner, it would shut itself down immediately. And the LGPL version 3 license particularly prohibits this. It requires any manufacturer of such a device to provide effective installation means and instructions, meaning you have to give people an effective, meaning a working means to modify your software and then to install it in whatever device that is and allow people to use that going forward. So the anti-TiVoization in version 3 is limited to something that is called user products. And that alleviates a little bit of the issue here. So for example, if you're in the medical device industry, maybe you think that you can breathe a little bit easier because clearly what you're doing is not a user product, or so a lot of other industries. You think to yourself, well, you know, thank heaven I'm not covered by that. But the definition of user products is probably broader than you think. So a user product is either a consumer product, and the consumer product is something that is it is the definition of consumer product as is adapted from the U.S. Act called the Magnuson-Moss Warranty Act. The United States has 3 decades of experience of liberal judicial and administrative interpretation of this definition in a manner favorable to consumer rights. And one well-established interpretive principle under Magnuson-Moss is that ambiguities are resolved in favor of coverage. In cases where it is not clear whether a product falls under the definition of a consumer product, the product will be treated as a consumer product. And if that wasn't enough, then it goes on to talk about anything that was designed or sold for incorporation into a dwelling is also a user product. And the definition of anything that's designed or sold to be incorporated into a dwelling is something that is supposed to be broader even than the definition of consumer product under the Magnuson-Moss Warranty Act. So what does that mean? Well, let me bring that home to people in particular. Let's suppose you are in the medical device industry, and you create a device that is intended to be used by doctors in hospitals. Sounds like you're probably safe from the strictures of this anti-TiVoization provision. Maybe not, because what you're doing then is you're foreclosing the ability to evolve that product so that you can bring it down to a level that people can take it home. People can use it in their own homes. You are limiting yourself under those circumstances to use in the hospital setting, that you're foreclosing that entire expansion of the market going forward. What about things that are intended to be used just in, not only in hospitals, but also in places like nursing homes? Nursing home is something that is certainly a dwelling place for numerous people. And so if you're talking about resolving ambiguities in favor of coverage, something that's designed or sold for incorporation in a nursing home is something that is something that could be considered to be a user product. And I guess finally, what I would have to say is that this was a tough enough issue, and this was an expansive enough definition back in February of 2020. The way the world has changed since then, and with the expansion of everything that we are using in our households now, the expansion of everything that we are using in our own dwellings has simply turned the world upside down as far as that is concerned. So anything that you have previously said, oh, that's not something that's used in people's households or not used in people's personal dwellings, reconsider that, because it may very well be that that has changed over the last 8 weeks. Can't do this without talking a little bit about the scary stuff, which is what we lawyers like, of course. What happens if you do violate the license agreement? So first of all, the good news about version 3 is that it does provide you with an opportunity to cure. So you can go back and you can try to fix whatever it is that you've done wrong and bring yourself into compliance. And I will tell you that despite what people were screaming about back in the 1990s, a court is not going to order you to publish the source code to all of your proprietary software products. It's not going to happen. But the structure of the license model, the structure of the paradigm of you are licensed to use this is very important. Because if you violate the open source license, it's not that you've breached the contract and you're liable for contract damages. It's that you no longer have the right to use or distribute that software. And what that means is if you use or distribute that software without the requisite license, you are liable for copyright infringement. And copyright infringement is a statutory violation. It is not breach of contract. And statutory remedies apply, including in some circumstances, statutory damages of $50,000 per copy under these circumstances. And the contractual limitations that you might have built into contracts that you carefully negotiate with your suppliers and vendors wouldn't be applicable under these circumstances. Finally, the whole issue of who enforces these licenses. So all of this goes on, and it's not clear to you who it is that's going to actually come after you and say, hey, you've got to comply with this. And the entities who own the software copyright are clearly the entity that is most likely and most able to enforce these. So the various foundations, such as the Free Software Foundation or the foundation, not the Qt company, the foundation that is the proprietor of Qt open source, have the ability to enforce those licenses. But there's also been the beginning of what I see as a very, very significant development. And many of you may have heard of the legal case from a couple of years ago called Cokinetic Systems versus Panasonic Aviation. And this was a case, Cokinetics was a licensee / competitor of Panasonic. And they brought an antitrust action against Panasonic using a very, very novel theory. And that was, their theory was that Panasonic was not complying with their obligations under their open source licenses. And that even though Cokinetics was not the proprietor who could enforce that, it was an antitrust violation for them to do that. And the lower court, at least initially, agreed that that was a viable legal theory. And then what happened from there is what often happens in legal circumstances under our common law system. After that opinion was published, that bit of law is now out there in the ecosphere. The case settled. And it's as far as an appeals court or somebody like that being able to correct or overrule or even comment on that theory, that has gone away. So that theory about a competitor being able to claim that an open source violation is an antitrust violation is a doctrine of law that has support from at least one previous case. Other entities that might take a serious look at whether you're complying with your open source licenses are regulators. So for example, if you have to lock your device because it's a highly regulated device and has to be tested and certified and manufactured using certain principles, if you have to open that device because you are using open source software in that device, regulators may look at that with disdain. And again, going back to the Free Software Foundation and what their attitude is towards exactly that circumstance, again, quoting from the comprehensive tutorial, their belief is that imposing technical barriers to modification is wrong regardless of the circumstances. So technical barriers to being able to use your own defibrillator and you know, take it home on the weekends and further develop the software, they believe that that's something that should not be prohibited. And finally, as I say, acquirers, people who are looking to acquire your company will, number one, want to make sure that you're not using certain types of software licensed under certain licenses. And number two, they will want proof that you are complying with your obligations, because they are not going to want to be buying into a lawsuit or some sort of violation that they will then have to clean up in the future. So those are all circumstances that I would suggest to you folks that are looking and making the decisions as to whether you want to use free and open source software or whether you want to use commercial software, will have to consider. And I look at it this way, you know, you build a building and you put you put sprinklers in the ceilings, and you put fire retardant in the walls, and you do all sorts of things to make it as safe and fireproof a building as you possibly can. You also go out and you buy fire insurance at the same time. And I would suggest to you that using commercial software with the exact same functionality as open source software is, in some circumstances, that exactly that insurance. It's something that insures you against having to comply with the obligations of an open source license that might not be appropriate under your particular circumstances. So with that, I will pause for the 5 minutes of the standing ovation. And I really want to thank all of you for staying with me, and appreciate your listening to me babble on. Thank you. And Nikki, I'll just ask if people have questions. Oh, one of the questions that I've received here is somebody asked, does the anti-TiVoization clause mean that embedded devices wishing to enforce a secure boot must use a commercial license? So I mean, the basic, if by what you mean is a secure boot, means that the software within that device cannot be modified by the user, by the consumer, then I think the answer is yes, that's what you need to do in order to be able to enforce that security is to use a commercial license under which you can prohibit people from being able to do that, and under which you do not have to provide the complete and corresponding copy of the source code to people. Somebody asked to define the use of free and open source software. If I use free and open source software unmodified as a framework for my application, is there an issue? I think the answer to that is that there is less of an issue. So, for example, if you use free and open source software and you do not modify it in any manner whatsoever, you don't necessarily have to yourself provide a copy of the corresponding source code to your customer. You can simply point them to the same place where you got that copy and say, here is where you can obtain a copy of that. The patent provisions are not nearly as onerous if you do not modify things. So remember, I talked about this contributor version of free and open source software. That is different from an unmodified version. So if you simply take open source software and you pass it on without making any modifications to it, then the patent license that I talked about does not apply. But if you modify any portion of that, then the patent license applies to all of it. Somebody asked a question about they're developing an engine using Qt that they're developing using an open source license, and then they intend upon product launch to purchase a commercial license so that they can sell it. And that's something that actually is problematic under the Qt commercial license agreement. So should probably talk to somebody from Qt under those about that specific circumstance. The Qt commercial license prohibits the mixing of open source and commercial Qt. So in other words, if you want to distribute under commercial terms, you have to be pure with regard to your use of commercial Qt. So there's two types of mixing that we talk about. There's what I call vertical and horizontal. The horizontal maybe is more instinctual, and that is you have 5 developers that are working on something. 3 of them have commercial licenses and 2 of them are simply using open source software. That doesn't work. That's mixing the 2 together. But what I call vertical is the same. You start using open source licenses, you use open source development licenses, you use open source development licenses, and then the day before you release your product, you switch to a commercial license so that you can distribute the product under commercial terms. I simply suggest to you that the Qt company wouldn't be able to do what it's doing. We wouldn't have a viable business model if we allowed people to do that and missed out on all of those years of being able to sell people developer licenses in order to do that. So I would encourage you to look, to talk to somebody, talk to a acute account representative about that, because that could be an issue. Somebody asked how the GPL license is enforced. If code I write under the GPL3 is used by another software developer without making my code available, what can one do? So if you are a contributor, if you take any item of open source software, whether it's GPL3 or not, and if you make a modification and sell it onward, you are a proprietor and a licensor of everybody who is downstream from you, and you have the ability to enforce that license agreement and require them to comply with the obligations of their license. Somebody asked if my company is acquired and I have GPL version 3 in the software that they bought, will the acquiring company's patents be affected? Yes. So any one of your customers, so if you have product out in the field, any of your customers will, they will automatically receive a license under those circumstances. Was the aim of this presentation to scare us from using Qt under LGPL version 3? I guess the way that I would put that is that what I was intended to do, what I was asked to do, was to ask everybody to consider their particular circumstances, what they are developing and what they need to do in order to release a successful product. And you have to make an informed decision under your particular circumstances whether compliance with the LGPL version 3 is something that is acceptable to you, or whether it is a burden and a cost that makes it cheaper and easier for you to use commercial software. Both scenarios are absolutely appropriate. And I guess I would say I don't believe that it's a matter of worldview or philosophy or anything like that. That really what it is, it's a hard and factual evaluation of the particular circumstances of your product that should lead you to a decision as to go one way or another. Somebody asked, can I charge a fee if one component of my product is using GPL version 3? Yes, you can. I mean, you can charge a fee for the rest of your product, as long as you comply with the license, the GPL version 3 license with regard to that particular item of software. GPL version 3 software can be included in a commercial product. And with that, I am going to take a look and see that my time has expired here, and I will thank everyone for their attendance. I really appreciate it, and I've not been able to get to a lot of questions here. We'll try to do that in following up. So thank you all. Thank you very, very much. Take care.
Thank you all for joining us today. We appreciate your time.